This is English Shorthand dictation number 305, and the dictation speed is 100 words per minute. Ready? Start. Ladies and gentlemen, at the outset, I am thankful to the organizers of this conference for having given me an opportunity to inaugurate this conference and share my thoughts with you all. The conference is indeed a timely one, as the role of courts in upholding rule of law is getting more prominence than ever before. I am reminded of what Aristotle said about 2000 years ago regarding rule of law. He said that it is more proper that law should govern than any one of the citizens. Rule of law enjoins every citizen to be treated subject to law. Though there is no express mention about rule of law in our constitution, Articles 13, 14, 15, 16, 19, 20, 21, 22, and 368 provide for the inviolability of fundamental rights of the citizens. They are protected from all state actions which are inconsistent and in derogation of constitutional guarantees to protecting fundamental rights. In the earlier days, the role of courts was confined only to solving disputes between two individuals, but gradually courts have emerged as key participants in the public policy making process, exercising discretion to make decisions which have far reaching consequences in terms of the distribution of benefits and burdens within society. The powers of courts have grown in step with the spread of rights. If the other branches of the government do not respond to the demands of the society, courts have to step in so that the interest of the public is safeguarded. Courts are very often left with no alternative but to step into the vacuum of policy left by the executive, legislative, as well as executive acts of omission and commission may attract the wrath of judicial scrutiny when laws or other legislations or rules are inconsistent or in derogation of the fundamental rights offending the rule of law. There is a great expectation among lawyers and activists in favor of judicial review of executive decisions, but at the same time, the courts have to be careful in not crossing the line. Our Constitution has checks and balances for the harmonious functioning of executive, legislature, and judiciary. Separation of powers works within the parameters of checks and balances with the sole purpose of ensuring protection of rights as well as interests of the individuals and efficient administration to accomplish the task of social welfare state. The functions of the different branches of the government have been sufficiently differentiated by the Indian Constitution, and it does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. Thus, while embarking on the judicial review, the courts have to keep in mind the rights and responsibilities of the other two organs and ensure that they are not stepping into the jurisdiction of the other organs. I will be failing in my duty if I do not point out here about the role the lower courts have to play in upholding the rule of law. As you may be aware, pursuing claims in the lower courts is a difficult process, yet the litigants prefer to pursue the claims mainly because of the faith they repose on the system that the judicial process has legitimacy and that the judges are comparatively more trustworthy than their legislative and bureaucratic counterparts. Therefore, the lower courts have a duty to preserve and protect the economic and social rights of individuals at the grassroots. This we can ensure by providing more resources and greater financial commitment to the lower courts. The judges of the lower courts are overburdened, and the immediate need of the lower courts are additional judges. Already, the Honorable Supreme Court of India and the Government of India are taking steps to double the strength of judges, and proposals have been sent to the state government also. Next, if real changes are to be made, there needs to be a culture shift within the lower courts. It must begin with the lawyers, whom the litigants approach first. The lawyers have to advise their clients properly and guide them through the complicated maze of procedures in the lower courts. However, many of the lawyers at the grassroots level suffer from lack of critical skill sets. It is primarily because the legal education they receive within their law colleges often is inadequate. Books are outdated. English, which is the formal language of legal precedents from the upper courts, is not emphasized, and the infrastructure of the law college buildings is pathetic. In most of the law colleges, there is no opportunity to educate students through clinics or to engage them in critical analysis of the daily problems that they are likely to encounter in practice. If they are trained, it will go a long way in not only uplifting them but also will help in improving the plight of the litigants. At this juncture, we are proud to say that the Tamil Nadu State Judicial Academy is in forefront in organizing training programs for lawyers so that their contribution for the healthy judiciary would be more. Though it is unavoidable that conflicts do arise between the judiciary and executive, we have to bear in mind that the courts are complementary to the democratic process. Here, I would like to re emphasize the relevance of rule of law in today's time. Rule of law is a combination of interconnected notions of governance, rights, justice, and development. These notions pervade throughout the constitutional principles and decisions of the Supreme Court. At the same time, there are large parts of the populations for whom these ideas are merely on paper. Access to justice, therefore, is a crucial prerequisite before rule of law can be really upheld. The role of courts in this endeavor is immense, as the Indian courts today are not just for dispute settlement, but they are guardians for the trust of its citizens. The higher judiciary has played an important role in ensuring greater access to justice through public interest litigation and other procedural innovations. Yet, the structural limitations of such orders have prevented a substantial increase in access to justice.